Okay, welcome to this episode of Legally Noirette. Now we're going to talk about the source and limits of federal subject matter jurisdiction. All right. Unlike the state courts, which exercise very broad subject matter jurisdiction, the type of cases that federal courts can hear is extremely limited. The subject matter jurisdiction of federal courts is defined in Article 3, Section 2 of the Constitution, which lists the categories of cases federal courts may hear. Generally speaking, any case not on the Article 3 S2 or Section 2 list must be brought in state court. So here's the list. If it's not there, you're going to state court. Generally speaking, any case, already read that. The basic premise of the Constitution is that the federal government has the authority to exercise powers expressly or implicitly granted by the Constitution, but that all others, those not granted by the feds, are reserved for the states. U.S. Constitution Amendment 10. Under Article 3, Section 2, the federal courts are authorized to hear cases between states, between citizens of different states, between citizens and aliens, cases involving foreign ministers and councils, admiralty and maritime cases, cases arising under the federal Constitution and federal law, and a few other narrow categories of suits. In each of these types of cases, the framers perceived an important national interest. In cases between states, between citizens of different states, in cases between citizens and aliens, for example, they foresaw a risk of prejudice against the outsider, generally the defendant in state court. I don't know how to pronounce this, but admiralty and maritime cases and those involving ministers and councils involve international relations as to which the nation should speak with one voice. Similarly, it makes sense that federal courts should be able to hear cases that involve the application and interpretation of federal law, both to protect it from unsympathetic construction by state courts and to allow definitive interpretation of federal law. So if it's a conflict that is between two states, if it's a conflict between individuals from two different states, if it's a conflict that involves international issues, or if it's something about federal law, that goes to federal court. Everything else goes to state court because the federal court only has the right that is implicitly given to it by the Constitution. All right. Which makes sense because of the history of the establishment of this country. With this background, let's return to the Ingalls case. Several of the categories of Article 3, Section 2 might give a federal court constitutional authority to hear this case. Federal subject matter jurisdiction may be proper if Ingalls is diverse, that is, a citizen of a different state. Consolidated Article 3, Section 2 also provides federal courts the constitutional authority to hear Ingalls' case if it arises under a federal statute or under the federal Constitution. If her case does fit into one of those two cubbyholes in Article 3, Section 2, it appears that Ingalls will have to sue in state court. Remember the general premise that if a power is not granted by federal government under the Constitution, it remains with the states. These two categories of federal subject matter jurisdiction cases that arise under federal law and cases between citizens of different states, diversity cases, are by far the most common types of civil cases filed in federal court. This chapter will focus on the first category, which I shall refer to as arising under jurisdiction. The next chapter will tackle diversity. All right, so now let's talk about jurisdiction over cases arising under federal law, the problem. Article 3, Section 2 authorizes federal law to hear cases arising under this Constitution, the laws of the United States, the treaties made, or which shall be made under their authority. This provision obviously authorizes federal courts to hear at least some cases which involve federal constitutional issues or federal statutes, but the trick is to determine which claims that grand phase arising under federal law includes. Does it authorize federal jurisdiction over a case which involves federal law in any way, or some more limited set of cases? Here are some examples to illustrate the problem. Ingalls sues Consolidated under a federal whistleblower statute, which authorizes an employee who is discharged or disciplined for reporting violation of federal regulation to obtain reinstatement and damages from her employer. But do you really want to go back there after they filed you for being a whistleblower and they're dishonest? I mean, probably not. Ingalls sues Consolidated for breach of contract for firing her in the first year of a 3-year contract. Consolidated answers the complaint, raising the defense that it was required to discharge Ingalls under a federal statute barring employment of illegal aliens. Okay, so now they're trying to bring up her status. You didn't know she was an alien before she started working there? Ingalls is consolidated for bad faith discharge, a state tort claim which allows damages if the defendant discharges an employee for reasons which violate certain public policies. She claims that Consolidated fired her because she refused to engage in accounting practices which violate federal statutory accounting requirements for government contractors. Ingalls sues Consolidated for breach of contract, claiming that her contract was for 3 years, but Consolidated fired her after one. She claims that Consolidated hired her to administer a research program partially funded by grants from the federal government, but fired her for taking time off to stay home with a sick child. Federal law lurks in each of these cases in one way or another. In the first case, Ingalls is actually brought suit under a federal statute. In the second, she sues on the state contract claim, but Consolidated has asserted a defense involving federal law. In the third example, plaintiff sues on a state bad faith dismissal claim, but tries to establish the defendant's bad faith by showing that it required her to violate a federal law. In the last, federal law is only vaguely relevant, if at all. Examples like these illustrate that the courts need to develop some working standards to determine when a case which somehow involves federal law will arise under federal law. So let's go back to the last one. Ingalls sues Consolidated for breach of contract, claiming that her contract was for 3 years, but Consolidated fired her under one. So that would be a state issue, right? Then she claims that Consolidated hired her to administer a research program partially funded by grants from the federal government. So that's the federal government part, but fire her for taking time off to stay home for a sick child. So it says that the last one, federal law is only vaguely relevant, if at all, because they hired her under that federal contract. So now let's talk about jurisdiction over cases arising under federal law, the constitutional scope. So we talked about the federal law problem. Now let's look at the constitutional scope. The Supreme Court has long taken an expansive view of the arising under language in Article 3, Section 2. In Osborne versus Bank of the United States, 22 U.S. 738 and from 1824, Chief Justice Marshall, who advocated a strong national government, held that the case arises under federal law, as this phrase is used in Article 3, Section 2, if the title or right set up by the party may be defeated by one construction of the Constitution or law of the United States and sustained by the opposite construction. We think then that when a question to which the judicial power of the Union is extended by the Constitution forms an ingredient of the original case, it is in the power of Congress to give the lower federal courts jurisdiction of that cause, although such questions of fact or law may be involved in it. 22 U.S. from pages 822 to 823, under the broad holding of Osborne, the federal court could clearly hear the first above case, since the federal statute is the source of substantive right Ingalls claims. Jurisdiction under this federal ingredient approach would also extend to the second example case in which Ingalls sues under state contract law, but Consolidated claims as a defense that it was required to discharge her under a federal statute. The validity of this defense will clearly be an ingredient of the case, although that ingredient is injected by the defendant, not the plaintiff. Chief Justice Marshall reference in Osborne to the original case means to the case itself, not as under Motley, only in the claims asserted by the plaintiff in the case. A federal issue raised by the defendant would suffice under the reading. See Wright Federal Courts, 5th edition, 1994, page 102. The third case will arguably also come with this broad ingredient approach to arising under jurisdiction. Although Ingalls has sued under state tort law, in order to prove her bad faith dismissal claim, she will have to show that she was fired because of her refusal to violate federal regulations. Thus, proving her state law contract claim will require her to show that the accounting practice she refused to adopt will violate federal law. The last case described above would not arise under federal law, even under the broad test of Osborne. Presumably, for federal law to be an ingredient of the case, one of the parties in the case will have to rely on federal law to establish a claim or a defense in the lawsuit, or at least raise a federal issue in proving her case. While there is some peripheral relationship to a federal program in the fourth example, neither Ingalls nor Consolidated would need to refer to federal law to litigate the case. If Ingalls sued under Federal Parental Leave Act, the result would be different. But the facts given, neither her claim nor the company's defense would require evidence about any proposition of federal law. So it's peripheral to what happened, but it's not involved in how they would actually litigate. Is that the word that they use? Yeah, litigate the case. So that's it. If she talked about, okay, I have Federal Parental Leave Act because my child was sick, then okay, we can go to federal court. All right, so let's go back to the reading. Neither her claim nor the company's defense will require evidence about any proposition of federal law. So the bottom line is that the phrase arising under in Article 3, Section 2 is very broadly constructed. It is probably satisfied in any case in which a party seeks to rely on or establish a proposition of federal law in order to prove either a claim or a defense in the claim. In Osborne, Chief Justice Marshall even opined that any case brought by the bank, opined, is that how you say it? Even opined that any case brought by the Bank of the United States would arise under federal law since the bank was incorporated under a federal statute. Thus, the bank's very existence and its right to sue or be sued as an issue in any such case. This is a very broad, perhaps extravagantly broad conception of the reach of the framers arising under language in Article 3. The court has never been called upon to accept or reject the outer reaches of Marshall's view, but it has reaffirmed that the arising under language in Article 3 is broad enough to apply if substantial issues of federal law are raised by either party in the case. All right, so in Osborne, Chief Justice Marshall even opined that any case brought by the Bank of the United States would arise under federal law since the bank was incorporated under a federal statute. Thus, the bank's very existence and its right to sue and be sued are an issue in any such case. Okay, very broad. Okay, now we're going to talk about jurisdiction over cases arising under federal law, the need for both constitutional power and statutory authority. All right, now comes the problem. The court's decision at Osborne indicates that constitutional reach of arising under jurisdiction in Article 3, Section 2 is broad. However, Article 3 does not confer subject matter jurisdiction on the lower courts. In fact, Article 3 does not even create lower federal courts. It authorizes Congress to do so. Since Article 3, Section 1, judicial power shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Since Congress has the authority to create lower federal courts or not to, it has long been held that it also has the authority to define their jurisdiction within the outer bounds of possible cases described in Article 3, Section 2. Klein v. Burke Construction Co. In other words, if Congress chooses to establish federal trial courts like the federal district courts as they exist today, it may give them the authority to hear all the cases listed in Article 3, Section 2. But it may also, as it has, authorize them to hear some, but not all of the cases described in Article 3, Section 2. It would authorize them to hear diversity cases, but not cases arising under federal law or cases between states, but not cases between citizens of different states or cases between citizens of different states, only if an amount of controversy requirement is met. Let me go back. I don't understand this. Now comes the problem. The court decision at Osborne indicates that the constitutional reach of arising under jurisdiction in Article 3, Section 2 is broad. However, Article 3 does not confer subject matter jurisdiction on the lower federal courts. In fact, Article 3 does not even create lower federal courts. It authorizes Congress to do so. Article 3, Section 1, judicial power shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Since Congress has the authority to create lower federal courts or not to, it has long been held that it also has the authority to define their jurisdiction within the outer bounds of possible cases described in Article 3, Section 2, see Klein v. Burke Construction. In other words, if Congress chooses to establish federal trial courts like the federal district courts as they exist today, it may give them authority to hear all the cases listed in Article 3, Section 2, but it may also, as it has, authorize them to hear some, but not all of the cases described in Article 3, Section 2. It could authorize them to hear diversity cases, but not cases arising under federal law. or cases between states, but not cases between citizens of different states, or cases between citizens of different states only if the amount in controversy requirement is met. So this isn't saying that it is this way. It's saying, should the federal courts, district courts decide to, if Congress chooses to establish federal trial courts, because Congress has the power to do that, like the federal district courts exist today, then they also have the right to establish what jurisdiction goes to a trial court versus what jurisdiction goes to a district court. Federal courts may assume only the portion of Article 3 judicial power which Congress by statute entrusts them. Simply stated, Congress may impart as much or as little of the judicial power as it deems appropriate, and the judiciary may not thereafter, on its own motion, recur to the Article 3 storehouse for additional jurisdiction. So Congress has the power here, right? Once Congress established by statute, the federal courts assume only the portion of Article 3 judicial power that Congress by statute entrusts them. So Congress may impart as much or as little of the judicial power as it deems appropriate. And after it does that, the judiciary may not, on its own motion, recur to the Article 3 storehouse for additional jurisdiction. So once Congress gets involved and says, this is the power that you have, federal courts, they can't go back and say, well, Article 3 says we can do this. They can't do that. They can only do the judicial authority that Congress has given them once it's been established. When it comes to jurisdiction in federal courts, truly to paraphrase the scripture, the Congress giveth and the Congress taketh away. Funny. Senate Select Committee versus Nixon. It follows from this basic fact that a lawyer seeking to file a lawsuit in federal court must ask two questions in determining whether a suit may be filed there. First, is this case one which constitutionally may be granted to the federal courts because the power for them to hear it is granted in Article 3, Section 2 of the Constitution? And second, if the case does not fall into one of the categories in Article 3, Section 2, has Congress actually conveyed jurisdiction over this type of case in a federal statute? So two questions. Was it constitutionally granted the authority to federal court to hear this type of case in Article 3, Section 2 of the Constitution? And second, if the case does fall in one of the categories of Article 3, Section 2, if it doesn't, and second, if the case does fall into one of the categories in Article 3, Section 2, has Congress actually conveyed jurisdiction over this type of case in a federal statute? So first, is the case one which constitutionally may be granted to the federal courts because of the power for them to hear it is granted in Article 3, Section 2 of the Constitution? And second, if the case does fall into one of the categories in Article 3, Section 2, has Congress actually conveyed jurisdiction over this type of case in the federal statute? Because we're going back to what happened once Congress by statute entrusts the federal court a portion of Article 3, that federal court judiciary cannot on its own motion recur to Article 3 storehouse for additional jurisdiction. So one, was it constitutionally granted? And then two, did Congress convey that jurisdiction over this type of federal statute? There are many illustrations of cases within the federal judicial power under Article 3 that Congress has not authorized federal courts to hear. For example, for many years, there was no broad grant of arising under jurisdiction to the lower federal courts. Prior to 1875, there were narrow statutes authorizing jurisdiction over cases arising under particular federal laws, such as the federal revenue statutes or federal patent statutes, but there was no broad grant of arising under jurisdiction. It was only after the Civil War when Congress doubted the willingness of the state courts in the southern states to enforce the new federal civil rights statutes that it granted broad jurisdiction over cases arising under federal law to the lower federal courts. Wow, let's see. For many years, there was no broad grant of arising under jurisdiction to the lower federal courts. Prior to 1875, there were narrow statutes authorizing jurisdiction over cases arising under particular federal law, such as the federal revenue statutes or federal patent statutes, but there was no broad grant of arising under jurisdiction. It was only after the Civil War when Congress doubted the willingness of the state courts in the southern states to enforce the new federal civil rights statutes that it granted broad jurisdiction over cases arising under federal law to lower courts. So they were afraid that that if it went to state court, they would not they would not protect the federal civil rights statute. So therefore, they had to give the lower courts the right to hear it. Another example is a case between a citizen in Minnesota and a citizen in Illinois demanding $35,000 in damages. This is a case between citizens in different states, so it is within the diversity jurisdiction authorized in Article 3, Section 2. However, Congress has not seen fit to allow this diversity case into federal court because, according to 1332A, the statute that confers diversity jurisdiction in federal district courts limits the jurisdiction to cases in which more than $75,000 is in controversy. So yes, there's diversity, but the amount of controversy is not great enough to go to a federal court. Okay. There are many illustrations of cases within the federal judicial power. Oh, I read that already. All right. All right. So today, 28 U.S.C. Section 1331, the statute by which Congress bestows arising under jurisdiction on the federal district courts, authorizes jurisdiction over cases arising under the Constitution, laws, or treaties in the United States. Because the statute conveys the arising under jurisdiction in the same language using Article 3, Section 2, one might reasonably conclude that Congress intended to grant the full reach of such jurisdiction in the federal district courts. To the broad extent of the court's interpretation of the arising under language in Osborne, however, such a reasonable conclusion would perplexingly be wrong. All right, so in this statute, Congress bestowed, used the same language as in Article 3, Section 2. So you would think, oh, all right, so it's the same. The article, this 1331 gives jurisdiction to federal district courts the same as what Article Section 3 do, but we're wrong. So why are we wrong? Construing the statutory arising under grant the enigmatic Motley rule. Is that how you pronounce it? Enigmatic. Enigmatic Motley rule. That's what I thought it was really. Even though Section 1331 grants jurisdiction in the same language as Article 3, Section 2, the federal courts have interpreted the reach of the statute much more narrowly than the constitutional scope of arising under jurisdiction. So even though the language is the same, federal courts have interpreted it more narrowly. 1331. Case is consistently held that Section 1331 only applies if the plaintiff's claim requires proof of federal law. The statute does not confer jurisdiction on the federal district courts over cases that involve federal law unless the federal issue is necessary to prove the plaintiff's claim. So even if there's a federal issue, if the federal issue is not necessary to prove the plaintiff's claim, then it's not going to be heard there. And so that is how that goes. All right, so now let's take a look here. Louisville and Nashville, I think Railroad versus Motley, 1908, illustrates the puzzling distinction between the meaning of arising under in Article 3, Section 2, and the meaning of the same phrase in Section 1331. In Motley, the plaintiffs were given lifetime passes for free travel on the railroad. In settlement of a claim for injuries that Motley had suffered in an accident. After honoring the passes for 30-some years, the railroad refused to renew them because Congress had passed a statute barring railroads from giving free transportation. The Motley sued to obtain their passes, and the railroad defended on the ground that the federal statute barred renewal. The Motleys had two responses to this argument. First, they argued that the statute was prospective only. Surely Congress must not have meant the statute to apply to passes granted by the railroad before the enactment. Second, argued the Motleys, if the statute were interpreted to bar their passes, it would be unconstitutional under the Fifth Amendment of the United States Constitution, since it would deprive them of vested property rights without due process of law. These were two substantial, hotly contested questions of federal law. A person of common sense would be justified in concluding that a case which raised them, which indeed turned on them, would arise under federal law. Indeed, the parties in the trial court thought so, for no one questioned the federal court's jurisdiction in the trial court. No party questioned it on appeal to the United States Supreme Court either. Yet the court raised the subject matter jurisdiction issue itself and concluded that the lower federal court had lacked jurisdiction to hear Motley's case. How can this be? The court explained that for a plaintiff to sue in federal court under the statutory test for arising under jurisdiction, she must assert a claim that arises under federal law. The Motley's case did not. They had sued for breach of contract, a state law cause of action that did not require them to prove any proposition of federal law. They could establish their right to relief simply by proving that the railroad had agreed to renew the passes and they refused to do so. True, the railroad had given the federal statute as reason for failing to renew the passes, and it was clear that they would rely on the statute as a defense in responding to Motley's suit. However, the statute would naturally arise as a defense, not as an element of the Motley's case in chief. It was up to the Motleys. It was up to the Motleys to state their claim in their complaint and to leave it to the railroad to raise whatever defense it chose. And it was clear that the Motleys' claim arose under state contract law, not federal law. Note several things about the counterintuitive holding. First, it is clear that the case would come out differently if the court interpreted the statute, now Section 1331, as broadly as it had interpreted Article 3, Section 2 under Osborne. The federal statute was clearly an ingredient to the case. Indeed, the irony of Motley is that the only disputed issues in the case were issues of federal law. Second, under Motley, it is not enough for the plaintiff refers to federal law in her complaint. Second, under Motley, it is not enough for the plaintiff. It is not enough that the plaintiff refers to federal law in her complaint. The Motleys did refer both to federal issues in their pleading. The problem is that they didn't have to. They could have stated a perfectly adequate claim for relief by alleging only contract breach and the demand for specific performance. Under Motley's well-pleaded complaint rule, the court, in deciding whether the case arises under federal law for purpose of Section 1331, asked whether the plaintiff would have to raise the federal question issue in a complaint which includes the elements she needs to prove to establish her claim, and only those elements. Wow. So this is the thing. Yeah. So there's more than one way that you can bring a case about, and there's more than one complaint that you can make. So if they have to make the federal complaint, then that can give them arising under subject matter jurisdiction. But in this case, they had the choice to make a different complaint. They could have made the complaint contract breach. So the fact that this was not the only choice, is the way that I understand it, makes the federal court not have arising under subject matter jurisdiction. Jurisdiction under Section 1331 must be determined from what necessarily appears in the plaintiff's statement of his own claim in the bill or declaration. Jurisdiction under Section 1331 must be determined from what necessarily appears in the plaintiff's statement of his own claims in the bill or declaration. This is from Taylor v. Anderson in 1914. Not from any anticipated defenses the complaint alleged that the defendant will assert. The Motley case illustrates and applies the well-pleaded complaint rule, but provides it doesn't provide the student with precious little to explain its rationale. Why shouldn't a case that involves a genuine issue of federal law qualify for federal court jurisdiction, regardless of who arises the federal issue? Perhaps it should, yet the Motley rule remains the law today, primarily because it furthers sensible judicial administration. Courts need to determine their jurisdiction from the outset. The Motley rule allows the court to do so based solely on the plaintiff's case before the defendant answers. If Motley had been decided the other way, plaintiffs might invoke federal jurisdiction simply by referring in their complaints to defenses that they expected the defendant to raise, or by speculating about ones the defendant could raise, simply to create a federal subject matter jurisdiction. Under the well-pleaded complaint rule, the court is able to determine at the outset whether it has jurisdiction based on the claims the plaintiff has asserted without waiting for the defendant's answer. So this is the rationale for it. It says courts need to determine, so the well-pleaded complaint, so the case, it illustrates the well-pleaded complaint rule. It means that courts need to determine their jurisdiction from the outset, just on the complaint from the defendant. It should not have to wait from the response. I'm sorry, just from the complaint of the plaintiff. It should not have to wait for the response of the defendant in order to understand whether or not it has jurisdiction. Okay, so why is this? Plaintiffs could invoke federal jurisdiction simply by referring in their complaint to defenses they expected the defendant to raise, or by speculating about ones the defendant would raise, simply to create a federal subject matter jurisdiction. So the plaintiff is the one who starts it, and so the court needs to decide on them. Otherwise, the defendant could think about what the plaintiff might say, or think about defenses that they could use simply to make it a federal issue, and we don't want that. So therefore, the well-pleaded complaint rule tells us that the jurisdiction must be decided simply based on the complaint. Okay, so applying the Motley rule, the Holmes creation test. Sorry about the interruption. I'm back. Okay, applying the Motley rule, the Holmes creation test. Justice Olive Wendell Holmes suggested a test for determining when Motley's well-pleaded complaint rule is met. He suggested that a suit arises under the law that creates the cause of action. So Oliver Wendell Holmes, so he created the Holmes creation test. So he said a test for determining when Motley's well-pleaded complaint rule is met is that a suit arises under the law that creates the cause of action. So this is American Well Works v. Lane from 1916. The Holmes test would find jurisdiction under Section 1331 if the source of the plaintiff's enforceable legal right against the defendant is federal law. So it says, let's repeat that again. It says that the source of the plaintiff's enforceable legal right against the defendant is federal law. In Motley, the source of the plaintiff's right to demand relief from the court was state contract law. The Motleys could sue the railroad because the state common law of contracts allows courts to order specific performance where a party makes a contract and fails to perform its obligations. Since the law that creates the cause of action was state law, the claim did not arise under federal law within the meaning of Section 1331. By contrast, in our first example, if Ingalls sues under the federal whistleblower statute, the Holmes test is met. Okay, so let's look at the difference. The Motley could sue the railroad because the state common law of contracts allows courts to order specific performance where a party makes a contract and fails to perform its obligation. So they could demand relief under state contract law. By contrast, if Ingalls sues under the federal whistleblower statute, the Holmes test is met. The reason that Ingalls can demand damages from Consolidated is that the federal statute bars employers from discharging or disciplining their employees for reporting violations of federal regulations and authorizes such employees to sue for reinstatement or damages if the employer does so. So I'm thinking in most cases people want damages, because talk about a hostile work environment. I mean, you want to go back there, they're like, ooh, she a tattletale. Nobody wants to work with a tattletale. Nobody wants to work for somebody dishonest. So clearly this is a mismatch in morality here. All right, so let's go back to the book, past my commentary. Okay. Compare the third example case in which Ingalls sues for bad faith discharge, a state law cause of action. This case fails the Holmes test since Ingalls sues on state. Compare the third example case in which Ingalls sues for bad faith discharge, a state law cause of action. The case fails the Holmes test since Ingalls sues on a state law claim. Here, her right to relief is created by state tort law. The common law cause of action for bad faith discharge. However, to recover on her state law claim, Ingalls will have to prove a proposition of federal law that the accounting practices she refused to engage in violated the federal statute, so that she was justified in refusing to engage in them. Arguably, This should be sufficient to support arising under jurisdiction, since the plaintiff will have to establish a proposition of federal law in order to prevail. However, Holmes' test would leave this one out. All right, so compare the third example case in which Ingo sues for bad faith discharge, a state law cause of action. This case fails the Holmes test since Ingo sues on a state law claim. Here, her right to relief is created by state tort law, the common law cause of action for bad faith discharge. However, to recover on her state law claim, Ingo would have to prove proposition of federal law that the accounting practices she refused to engage in violated the federal statute, so that she was justified in refusing to engage them. Arguably, this would be sufficient to support arising under jurisdiction, since the plaintiff will have to establish a proposition of federal law in order to prevail. However, the Holmes test would leave this one out. One fair rule of thumb in this area, in which unfortunately most rules turn out to have exceptions, is that if a case meets the Holmes test, it does not arise under federal law. Is that if a case meets the Holmes test, it does not arise under federal law for the purposes of Section 1331. I don't understand that. One fair rule of thumb in this area, but there's also exceptions, is that if a case meets the Holmes test, it does not arise under federal law for purposes of Section 1331. Mr. Justice Holmes' formula is more useful for inclusion than for exclusion, for which it is intended. It's more useful for inclusion, so finding cases that are that arise under federal law, versus exclusion, finding cases that don't. I believe that's what it means. TB Harms versus Eliascu. The vast majority of cases brought under the arising under jurisdiction fit neatly within the Holmes test, and consequently, there is no question that the federal court has jurisdiction under Section 1331. Here are two easy examples. The federal copyright statute provides that authors have the exclusive right to perform or reproduce their original works. The statute also authorizes injunctive relief against any person who uses copyrighted works without permission. Shakespeare writes a play about a prince. The Elizabethan Publishing Company gets hold of the copy and announces publication of the same play. Shakespeare sues for an injunction. Here, the federal copyright statute both creates a federal substantive right, the right to exclusive use of original works, and authorizes him to sue for violation of that right. Thus, his suit clearly satisfies the Holmes test. All right, so let's go back. What is the Holmes test? The Holmes test, again, I need to remind myself. He suggests that a suit arises under the law that creates the cause of action. A well-pleaded complaint rule is met. He suggested that a suit arises under the law that creates the cause of action. So because it was a federal law that created the cause of action, where he's suing for, he has the right to this original works under the federal copyright statute, and then he has the right to injunctive relief. All right, now let's look at example 2. The Eighth Amendment of the United States Constitution, which bars cruel and unusual punishment, has been interpreted to require jailers to provide medical care for prisoners in their charge. Wilson, a prisoner in a state prison, is taken violently ill, but the guards ignore his pleas for medical help, leading to serious complication. He sues under the 42 USC section 1983, which authorizes any person deprived of rights under the United States Constitution by state actors to sue for damages. Here, the United States Constitution creates a substantive right, the right of a prisoner to be free of deliberate indifference to his serious medical needs, and a federal statute authorizes him to sue for damages for deprivation to that right. Again, there is no question that federal law is the source of Wilson's claim, and that jurisdiction will be proper under Section 1331, because this suit arises under the law that creates the cause of action. So both of these suits arise under people disregarding federal law. These two examples are easy because in each, federal law both creates the underlying substantive right the plaintiff seeks to enforce and authorizes plaintiffs to bring the suit to enforce the substantive right. So in both these cases, the federal law says, A, you have this right, and B, you have the right to relief if this right is violated. However, these two don't always go together. For example, Shoshone Mining Co. v. Rudder. The plaintiff sued the federal court to establish title to a mining claim. A federal statute authorized claimants to mining claims in the Western states to bring such suits to determine title to those claims, but provided that the merits of the ownership claim should be determined according to the local property customs or statute in the state territory which the property was located. In other words, the federal statute in Shoshone Mining authorized claimants to sue, but it did not establish federal law, which would govern the substance of the claims adjudicated. These were to be governed by local law. So they don't always go together, right? So it's like, yes, you can sue, but it didn't govern the substance of the claims adjudicated. These were governed by local law. Whether Shoshone Mining satisfies the home test depends on just what it means for federal law to create the cause of action. The homes mean that the right to sue, to go to court and seek a remedy must be granted by a federal statute, which was true in Shoshone Mining, or that federal law must create the substantive right, which is being enforced, or both. Unlike the two easy examples above, the Shoshone Mining federal law authorized parties to sue on mining claims, but did not create the cause of action. Local property laws provided the governing substantive law for claims brought under the statute. On essentially this rationale, the Supreme Court concluded that the claim in suit did not arise under federal law, a statute authorizing an action to establish a right. The court noted is very different from one which creates a right to establish. A statute authorizing an action to establish a right. The court noted is very different from one which creates a right to be established. A statute authorizing an action to establish a right. A statute authorizing an action to establish a right, the court noted, is very different from one which creates a right to be established. It's not hard to see why, as a policy matter, the court may have drawn this distinction in Shoshone Mining. Otherwise, a myriad of local property claims in the Western states involving no federal interest or law would have been swept into federal court under the arising under jurisdiction. So a statute authorizing an action to establish a right. So this statute authorizes an action that establishes a right, right? But that's not the same as one that creates a right to be established. So it authorizes an action to establish a right. So it gives you an opportunity to establish a right versus it grants you the right, which then later has to be established. So it's like under the copyright law, you have the right to have your works protected. And when somebody goes against it, you establish that right by looking for injunctive relief, I believe. That is where if it's a federal isuthat then you can take it to a federal court. And the other thing, it says he sued in federal court to establish title to a mining claim. So he didn't already have the claim. He sued in federal court to establish his claim, right? So the difference is if you already have the right and then you sue because somebody steps on your toes versus you sue to get the right. You think? That's what I think. But that's the question that I have. Okay. So beyond the creation test, state law claims turning on a substantial federal issue. All right. In another set of cases, federal courts have upheld arising under jurisdiction where federal law does not create the right to sue. In another set of cases, federal courts have upheld arising under jurisdiction where federal law does not create the right to sue. But the plaintiff, in order to establish her state law claim, must prove a proposition of federal law. An oft-cited example is Smith v. Kansas City Title and Trust Company from 1920. And Smith, the plaintiff, sued to enjoin Kansas City Title Trust from investing in certain bonds issued by federal banks under the authority of a federal statute. The plaintiffs claim that investing in the bonds would exceed the company's corporate powers since it was only authorized to invest in valid securities, and the bonds at issue in the case were invalid because the federal statute authorizing them was unconstitutional. The claim in Smith does not satisfy the Holmes test. The plaintiff sued to enjoin the corporation from exceeding its powers under the state corporation law, a state law, just as the Motleys sued to enforce a contract in Motley. However, the plaintiffs in Smith could not prove this state law claim without establishing a proposition of federal law. That the federal statute under which the bonds were issued was unconstitutional under the United States Constitution. The federal issue was embedded in the state law claim and essential to its resolution. The Supreme Court held that this claim satisfied arising under jurisdiction since the controversy concerns the constitutional validity of an act of Congress, which is directly drawn in question. The decision depends upon the determination of this issue. Justice Holmes dissented in Smith, arguing that the federal law must create at least a part of the cause of action by its force, for it is the suit, not a question of the suit, that must arise under the law of the United States. So he said that it has to be the suit, not a question in the suit that gives that must arise under the law of the United States. Later Supreme Court cases suggested that the Smith exception or alternative or whatever it is still a viable basis for finding jurisdiction under Section 1331. In Franchise Tax Board v. Laborers Vacation Trust, for example, the court stated, it is well settled that Justice Holmes' test is more useful for describing the vast majority of cases that come within the district courts. Original jurisdiction, that come within the court's original jurisdiction than it is for describing which cases are beyond the district court jurisdiction. We have often held that a case arose under federal law where the vindication of the right under state law necessarily turns on some construction of federal law. We have often held that a case arose under federal law where the vindication of a right under state law necessarily turned on some construction of federal law. So to vindicate your right under state law, you have to discuss it is turned on some construction of federal law. So the Supreme Court recently reaffirmed the viability of the Smith exception to the Holmes test in Gravel and Sons Metal Products v. DeRue Engineering and Manufacturing in 2005. In Gravel and Sons, the federal government had taken Gravel and Sons real property for non-payment of taxes and conveyed it to DeRue. Later, Gravel and Sons brought an action to quiet title, claiming the conveyance to DeRue was not valid because it had not received proper notice of the sale under the federal statute authorizing sales for non-payment of taxes. DeRue removed the case from federal court, arguing that the case arose. DeRue removed the case to federal court, arguing that the case arose under federal law because the nature of the notice required under the federal statute is a question of federal law. The case went up to the Supreme Court on the question of whether the federal district court had arising under jurisdiction over the case. The Supreme Court recognized that Gravel and Sons action arose under state law, a traditional property action to quiet title. It also recognized, however, that in Smith, Gravel and Sons could only establish its right to reclaim the property by proving a proposition of federal law. Whether Gravel was given notice within the meaning of the federal statute is thus an essential element of its quiet title claim, and the meaning of the federal statute is actually in dispute. The Gravel court held unequivocally that federal court ought to be able to hear claims recognized under state law that nonetheless turn on substantial questions of federal law. Court's opinion makes clear that the need to resolve a federal question to decide a state law claim will not always support arising under jurisdiction. However, the embedded federal issue must be substantial to support jurisdiction, and delicate judgments will have to be made about the importance of the federal issue and the danger of opening the federal courts to an excessive number of claims. So nothing is simple in this area, but Gravel certainly reaffirms that sometimes the need to resolve an issue of federal law to prove a state course of action will support federal jurisdiction. So sometimes the need to resolve an issue of federal law to prove a state course of action will support federal jurisdiction. Note that while cases such as Smith and Grable and Sons go beyond Holmes' creation test, they are faithful to Motley's well-pleaded complaint rule in a broader sense, since in determining jurisdiction, the court looks at what the plaintiff must establish as part of her case. Under this substantial federal case, under this substantial federal issue approach, Engel could argue that the federal court has subject matter jurisdiction over the third example case given on page 62, in which Engel sues for bad faith discharge, a state law claim that alleges that she was fired for refusing to violate a federal accounting requirement. Although state tort law creates the right to sue, in order to prove her claim, Engel would have to prove that she was fired for refusing to engage in conduct that violated the federal law. Okay, so she keeps substantial federal issue approach to say that the federal court has subject matter jurisdiction. So what I'm seeing is that you got to have a good attorney, because it's not just what your issue is, but it's how you choose to argue your issue, right? You need to have the best argument, because when you have the best argument, then you are more likely to get the jurisdiction that you want. So yes, there might be multiple ways to, is this skin a cat? Who wants to skin a cat? Where did that phrase come from? I don't know. But the point here at Legally Norway is we are trying to learn the law, and we're trying to do it using examples and explanations of civil procedure. All right, so now we have a couple more pages to read here. So now we're going to talk about a further complication, Merrill Dow and the relevance of implied federal causes of action to arising jurisdiction. Let's read that again. A further complication, Merrill Dow and the relevance of implied federal causes of action to arising under jurisdiction. While all this seems puzzling and does puzzle judges, lawyers, and federal court scholars as well, the basics are relatively clear. First, we know that jurisdiction under the arising under statute must be based on the plaintiff's claim. And second, we know that a case will arise under federal law if it satisfies the Holmes test, at least if it satisfies the Holmes test in both senses discussed above. That federal law creates the underlying substantive right plaintiffs seeks to enforce and authorizes plaintiffs to go to court for remedy. All right, let me go back and read that again. While all this seems puzzling and does puzzle judges, lawyers, and the federal court scholars as well, okay, so it's definitely going to puzzle me, who is a self-study law student, the basics are relatively clear. First, we know that jurisdiction under the arising under statute must be based on the plaintiff's claim. So jurisdiction under the arising statute must be based on the plaintiff's claim, so not on the defendant's response. And second, we know that a case will arise under federal law if it satisfies the Holmes test. So we know that a case will arise under federal law if it satisfies the Holmes test, at least if it satisfies the Holmes test in both senses discussed above. The federal law creates an underlying substantive right plaintiff seeks to enforce and authorizes plaintiffs to go to court for a remedy. So it gives them the right, and it also authorizes them to go to court for a remedy, like the copyright. Okay, somebody infringes your copyright, you have the right to ask for an injunction. It's worth noting that two principles probably resolve, it's worth noting that these two principles probably resolve 95% of cases. Usually jurisdiction under section 1331 is clear because the plaintiff sues under a federal statute, like the copyright statute, that both creates enforceable rights and authorize injured parties to sue for violations of those rights. Third, where a federal statute authorizes suit, but only to enforce a state cause of action, where a federal statute authorizes suit, but only to enforce a state cause of action, the court may well conclude that arising under jurisdiction does not exist, as the Supreme Court did in Schusching Mining. It's clear that this will always be so, but situations in which the federal statute simply authorizes a remedy for a state created right are likely to be problematic. Lastly, we have a twist. The Smith holding that a case cause of action can suffice. If proof, we have a twist. The Smith holding that a state cause of action can suffice if proof of that cause of action requires proof of a proposition of federal law substantially. Things would be complex enough if we could just leave it all, if we could just leave it at that. In fact, if you have not read Merodol Pharmaceuticals Inc. v. Thompson for your civil procedure class, I sincerely recommend that you do. Leave it at that. Skip the rest of this introduction and deal with the complexities raised by Merodol at some hopefully distant time in the future. Okay. Things would be complex enough if we could just leave it at that. In fact, if you have not read Merodol Pharmaceuticals Inc. v. Thompson for your civil procedure class, I sincerely recommend that you do leave it at that. Skip the rest of this introduction and deal with the complexities raised by Merodol at some hopefully distant time in the future. Merodol raised the problem, which is the converse of Shushing mining. Remember that in Shushing mining, federal law established the right to sue, but did not establish a federal substantive standard to govern the actual disposition of claims. Sometimes the opposite situation arises. Federal law creates a substantive right, but it does not, or at least does not expressly authorize plaintiffs to sue for a violation of their right. Here are two examples. Cannon v. University of Chicago involved a Title IX of the Educational Amendments of 1972 amendments to a federal statute. Those amendments bar discrimination on the basis of sex in any educational program which receives federal funds. However, the amendments do not expressly provide that a person who is subjected to such discrimination may sue for damages. Thus, the statute creates a substantive right to be free of sex discrimination in such educational programs, but it was unclear whether Congress also intended to create a right to sue for damages for deprivation of that right. The plaintiff sued in federal court alleging that she was a victim of discrimination barred by the amendments and claiming damages. All right. Title IX, J.I. Case v. Borak involves Section 14A of the Securities Exchange Act of 1934, a federal statute that bars companies from soliciting proxies in any manner prohibited by the rules of the Securities Exchange Commission. So, all right, Section 14A of the Securities Exchange Act of 1934, a federal statute that bars companies from soliciting proxies in any manner prohibited by the rules of the Securities and Exchange Commission. So the Securities Exchange Commission tells you how you can solicit proxies, and you can only do it in that way. A stockholder sued, claiming that the defendant company had issued false and misleading proxy statements in violation of Section 14A and seeking damages suffered as a result. Here again, the federal statute created a substantive standard of conduct, but it was unclear whether Congress also intended to authorize person claiming a violation of that standard to sue for resulting damages. In cases like these, if a plaintiff sues to enforce the federal right created by the statute, despite the lack of an express authorization, to sue, the court must decide whether there is an implied private right of action or right to sue to recover a violation of federal right. Over the years, the Supreme Court has established standards for determining when an implied right of action exists. Basically, the inquiry involves a search for congressional intent. In Cannon v. Borak, the court concluded that Congress did intend to authorize a private right of action for damages. In other cases, it has concluded that no private right of action was intended. If the court concludes that a federal statute does impliedly authorize suits for damages, there is no problem concluding that federal jurisdiction exists under 28 U.S.C. Section 1331. Such cases are slam dunk under the Holmes test, since federal law creates both a substantive claim that is being enforced and the right to sue for violations of that right. If a court concludes that a federal statute does impliedly authorize suits for damages, there is no problem concluding that federal jurisdiction exists under Section 1331. Such cases are slam dunk under the Holmes test, since federal law creates both a substantive claim that is being enforced and the right to sue for violations of that right, although by implication rather than expressly. However, the situation is more murky if the court concludes that the federal statute creates a federal right or standard but does not authorize private suits for damages to enforce it. This was the situation in Merodol. The plaintiff sued for damages allegedly caused by Vindictin, a drug manufactured by Merodol. They asserted claims based on negligence, breach of warranty, and strict liability, all state tort theories. However, one of their negligence theories was that Merrill Dow gave inadequate warnings of the risk of vindictive because warnings did not meet the labeling requirements of the Federal Food, Drug, and Cosmetic Act. Thus, the complaint alleged a state cause of action negligence, but asserted that the plaintiffs could prove this state cause of action by showing violation of the substantial standard governing warnings in the federal statute. In this sense, the case resembled Smith v. Kansas City Title and Trust and Gravel and Sons, in which plaintiffs brought state claim but had to establish proposition of federal law in order to recover. In Merrill Dow, however, there was a twist which led the court to distinguish Smith. All parties agreed that Congress did not intend to create an implied right to sue for damages for a violation of the Federal Food, Drug, and Cosmetic Act. To allow the Merrill Dow plaintiffs to go to federal court to sue for damages simply by alleging that failure to comply with the federal warning statute constituted negligence under state law would fly in the face of Congress's decision not to create a federal right to sue for damages for the Federal Food, Drug, and Cosmetics Act violations, the FDC. It would effectively create a federal court remedy where Congress had decided not to do so. Consequently, the court held that the reference to the Federal Food, Drug, and Cosmetics Act, the FDCA, and the state negligence claim was insufficient to create a rising under jurisdiction under Section 1331. Wow. So these people took this drug. Okay. I wonder what it was for. Vindictin. It was made by Merrill Dow, which I assume is Dow Pharmaceuticals now. And they said that they asserted all these state tort claims, negligence, breach of warranty, strict liability, but they had to prove that using the federal law because they said that it wasn't properly labeled under the FDCA, the Federal Food, Drug, and Cosmetics Act. However, the Congress did not intend for people to be able to sue, which I don't really understand why Congress did not create a federal right to sue for damages. Like things need to be labeled properly, clearly, but I don't know. Congress had decided not to do so. They had decided not to create a federal court remedy for this. So Merrill Dow, the plaintiff, had relied on Smith v. Kansas City Title and Trust Company. The court's rejection of the argument raised considerable controversy about whether Smith's federal issue embedded in the state claim exception to the Holmes test was overruled. Gravel and Sons put that speculation to rest. In Gravel and Sons, the court noted that Merrill Dow itself had distinguished Smith. It viewed Merrill Dow as an example of the court making the kind of individualized judgments about the substantiality of the embedded federal issue that Smith exemplifies. It also noted that recognizing federal arising under jurisdiction based on an allegation that noncompliance with federal regulation constitutes negligence would have attracted a horde of original filings and removed cases rising other state claims and remove cases rising attracted a horde of original filings and removed cases raising other state claims with embedded federal issues. Further, the court noted that in Merrill Dow, Congress had not provided a federal cause of action for violations of the misbranding regulation at issue. Further evidence that such claims were not sufficiently substantial to support arising under jurisdiction. Thus, after Gravel and Sons, Merrill Dow can be viewed as a sensitive application of a longstanding exception to the Holmes test, rather than a new, more restrictive approach to arising under jurisdiction. Thus, after Gravel and Sons, Merrill Dow can be viewed as a sensitive application of a longstanding exception to the Holmes test, rather than a new, more restrictive approach to arising under jurisdiction. All of this seems confusing, but at least the fundamentals are fairly clear. If you feel at sea, perhaps the following examples will provide a few beacons of light to guide you toward an understanding of the fundamentals. Assume in considering the examples that there is no basis other than arising under jurisdiction for suing in federal court. Okay, arising under jurisdiction. Ooh, goodness. Gravel and Sons was from 2005. All right, so only in 2005 were we able to go back to it and say Meryl Dow can be viewed as a sensitive application. It viewed Meryl Dow as an example of the court making the kind of individualized judgments about the substantiality of the embedded federal issue that Smith exemplifies. It also noted that recognizing federal arising under jurisdiction based on an allegation that noncompliance with the federal regulation constitutes negligence would have attracted a horde of original filings and removed cases arising from other state claims which embedded federal issues. So they really, and maybe it's because the federal court system is so small, but there definitely is a propensity to keep issues in the state court, right? The federal courts don't have as many courts, they definitely don't have as many judges and things like that. But it says that it exemplifies the Smith v. Kansas City title case because it's saying that we're going to look at each case individually to see whether it has basis to be in a federal court under arising under jurisdiction and suing in federal court. All right, so that is chapter 4. I'm going to figure out how to do the examples, but chapter 5, we're going to talk about diversity jurisdiction. When does mutinous diversity jurisdiction. All right. So yeah, I think I might do shorter videos, one for each subheading, and that'll make it a little bit easier for me, but it may be a little bit easier for you too. So thank you for tuning in to Legally Noirette, Legally Raven Hair, Legally Black Hair, Legally Brunette. I don't know what to call it, but maybe in 4 years, we'll see. Bye.